So imagine you sign this ironclad, beautifully drafted contract to buy, I don't know, a commercial building for $2 million.
Right, a massive deal.
Exactly. It's signed, sealed, delivered. You both shook hands. But then, like, months later, a judge completely throws that written document out the window.
Oh.
Yeah, and they do it just because of some quick whispered conversation you had at a coffee shop the week before you signed.
Which sounds crazy, right?
It sounds completely impossible. Like, how can a casual chat override a $2 million written document?
Right.
Or, conversely, imagine you have an email that explicitly promises you this massive discount on a deal, but the judge refuses to even look at it.
They just pretend it's not there.
Yeah. They tell you your email effectively doesn't exist.
Yeah.
So, welcome to this deep dive. If you're listening to this right now, you are putting in the hours preparing for the multi-state bar examination.
The dreaded MBE.
This dreaded MBE. You are grinding through practice questions, and you have inevitably slammed right into one of the most notoriously frustrating walls in contract law.
Oh, absolutely. The doctrine and application of parole evidence.
That's the one. And our mission today is to just completely demystify this rule for you. Especially, if English is your second language, this stuff is dense.
It's an absolute minefield on the bar exam. I mean, the frustration so many examinees feel is incredibly common because the rule, well, it seems to contradict itself,
Right.
On one hand, the law tells you the written contract is sacred.
Yeah.
But then on the other hand, the law gives you like a dozen different ways to completely bypass that written contract.
Exactly. So we're going to map out the entire architecture of this doctrine today using your specific source material. That way, when you see a fact pattern on the exam, you'll know exactly which legal mechanism is being triggered.
That's a great approach.
Let's start by just translating the title itself, the parole evidence rule. Now, when you hear the word parole, you usually think of criminal law, right? Like a prisoner getting out of jail early.
Right, getting out on parole. But this is a completely different concept.
Totally different. In this context, parole, which is spelled P-A-R-O-L, by the way, no E at the end, historically meant oral or spoken.
Which is where a lot of the confusion starts.
Yeah, because in modern contract law, it's evolved. Parole evidence means literally any outside evidence that isn't physically inside the final written document.
Exactly.
So we're talking about verbal conversation, sure, but also emails, text messages, sticky notes,
Drafts.
napkin sketches. If it's not inside the final printed document, it is parole evidence.
And, that vocabulary distinction alone will save you points on the exam because parole is really just synonymous with extrinsic.
Extrinsic, right.
Yeah, extrinsic simply means external or outside. And before we get into the complex mechanics of how the rule actually operates, we have to understand the fundamental philosophy behind it.
The why?
Right, the why. The legal system places a massive premium on certainty. I mean, imagine the chaos in the business world if any party could sign a formal agreement, wait 6 months until they regret the deal, and then just drag the other person into court.
Saying something like, well, the day before we signed this, you verbally promised me something completely different.
Exactly. The courts would be permanently clogged with these he said, she said disputes over casual conversations that happened, months or years ago.
So the rule is basically a shield.
Precisely. The law wants to reward people who take the time to formalize their agreements in writing. It wants that final piece of paper to be a reliable, historically accurate record of the deal.
Right.
So the parole evidence rule acts as this protective shield around the final document, keeping people from rewriting history.
Okay, to make this really intuitive as you're working through MBE questions, we're going to use a core visual for this deep dive. I want you to imagine that the final written contract is an exclusive, highly sought-after VIP club.
I love this analogy.
Right. And the parole evidence rule. That is the massive, completely uncompromising bouncer standing right at the front door.
Crossing his arms.
Exactly.
Yeah.
Today, we're going to learn exactly whose IDs get rejected at the door by this bouncer and who actually holds the secret passwords to bypass the velvet rope and get inside the club.
Well, the source text gives us the bouncer's basic instructions right off the bat. The general rule states that evidence of prior or contemporaneous agreements is not admissible to contradict the terms of a written agreement,
Right.
assuming all the terms are completely integrated into the four corners of the agreement.
Okay, there is a very dense layer of legal vocabulary in that single sentence. Let's isolate the timeline first, because that's huge. The bouncer specifically blocks prior agreements.
Yes.
That covers literally anything discussed before the moment of signing. So if you're signing the contract on a Friday Any emails from Thursday,
Phone calls from Wednesday.
right, or handshakes on a golf course from a month ago, those are all prior agreements. They are outside the club.
Hmm.
But then we have contemporaneous agreements.
And contemporaneous just means happening at the exact same moment.
Okay, so paint a picture of that.
Picture two business owners sitting across from each other at a conference table, right? They're physically signing the documents. And while they're signing, one leans over and whispers, "Hey, we agree that the delivery is going to be free, right?"
And the other guy just nods and keeps signing.
Exactly. That whispered conversation is a contemporaneous agreement. It occurred simultaneously with the execution of the contract.
And according to the general rule, those prior things and those contemporaneous things are not admissible to contradict the written agreement.
Contradict being the key word there.
Right, so if the contract they're signing explicitly says delivery costs $500, that whispered promise of free delivery is completely barred from the courtroom.
The judge will not hear it.
The bouncer just kicks it into the alley because it is a direct contradiction of the written text.
But the general rule comes with a massive prerequisite at the very end of that sentence.
The four corners part.
Yes. This strict exclusion only applies when the terms are completely integrated into what the text calls the four corners of the agreement.
Which is such a wonderfully literal visual. Just imagine holding the physical piece of paper that the contract is printed on. That paper has four physical corners.
Right.
The court's perspective is entirely restricted to the area inside that rectangle. If your special promise about free delivery is not printed somewhere within those four physical corners, the court just puts its blinders on. The entire universe of your deal is defined by the borders of that page.
However, the court doesn't just automatically assume that every single piece of paper with writing on it is a magical four corners document.
Right, like a grocery list isn't a contract.
Exactly. The absolute foundation of the parole evidence rule is intent. The source material really emphasizes this. To invoke this rule, it must be shown that the parties actually intended to adopt the writing as their entire agreement.
So if two people are mapping out a business plan on a whiteboard, or scribbling terms on a napkin over lunch, and it's clearly just a preliminary brainstorming session,
Then the parole evidence rule doesn't trigger at all.
there's no VIP club to protect yet.
Right, the bouncer stays home. You have to prove that both parties looked at that specific document and mutually agreed, this is it. This is the official, final expression of our deal.
Okay, and the text categorizes this under the heading of intent, pointing out that intent dictates where a document falls on the spectrum of integration.
Yeah, and integration is simply the legal term for completeness.
Just how complete is this written document?
Exactly. The examiners will test your ability to recognize where a contract sits on this spectrum, and there are three main spots: no integration, partial integration, or total integration.
Let's walk through that spectrum, starting with no integration. We just touched on this with the napkin sketch, right?
Yeah.
If it's a draft, a preliminary outline, maybe an unsigned proposal, there is zero integration. The document isn't final. And because there is no final expression to protect, the parole evidence rule is entirely irrelevant.
You can bring in whatever outside emails or verbal conversations you want.
Right. Then we swing all the way to the opposite end of the spectrum, which is total integration. The source material also refers to this as a completely integrated agreement.
And this means the document is the absolute 100% final, comprehensive expression of every single detail the parties agreed upon. It is the alpha and the omega of the deal.
When a contract is totally integrated, our bouncer is operating at maximum security. The text states that parole evidence cannot be used to contradict any term of a final and complete writing.
Which makes sense based on what we said earlier.
Right. But furthermore, no evidence can be introduced regarding any additional promises or representations made prior to the writing.
And that second part, that is where students often lose points on the MBE.
Okay, break that down for us.
Well, we know you can't contradict the writing. If the price is listed at $10,000, you can't introduce a prior email saying the price is $8,000. That's obvious.
Sure.
But total integration means you also cannot bring in outside evidence to add additional terms, even if those terms don't technically contradict anything.
Let's ground this in an MBE-style hypothetical. Let's say you and I sign a contract for me to buy your used car for $10,000. The contract lists the make, the model, the VIN, the price, the date of sale. We both sign it, and let's assume it is totally integrated.
Okay, got the picture.
Now, a month later, we're in court, and I try to submit an email from you, sent a week before we signed, where you promised to throw in a set of premium winter tires for free.
Now, think about it. The winter tires don't contradict the $10,000 price tag. They don't contradict the VIN or the make of the car.
No, they don't.
They're merely an extra supplementary promise.
But because the contract is totally integrated, the judge will reject that emails, right?
Absolutely. The court's logic is that if the winter tires were truly part of this comprehensive final deal, you guys would have written them into the document.
Since they aren't inside the four corners, they basically don't exist. I cannot add additional terms to a totally integrated contract. The club is sealed shut.
Exactly. Now we have to explore the middle ground, which requires a much more nuanced analysis, and that is partial integration.
Okay.
A partially integrated agreement is final and binding regarding the specific terms written within it, but it does not represent the entire exhaustive universe of the parties' discussions.
Like, it's a final draft of the first 3 chapters, but it leaves room for chapter 4.
That's a great way to put it.
So how does the bouncer handle a partially integrated club?
The rule is that a partially integrated agreement can be supplemented, but it cannot be contradicted.
Okay, so let's go back to our car sale hypothetical.
Hmm.
If the judge determines our contract was only partially integrated, the rule against contradiction still stands, right? I still can't bring in an email claiming the price was $8,000 instead of $10,000.
Right, the bouncer still kicks that out.
But because the document isn't a complete expression of every single thing we discussed, I can bring in the email about the winter tires.
Yes, because the winter tires are a consistent additional term. They supplement the agreement without fighting it. The bouncer lets that specific email into the club.
That dynamic right there, total integration blocking supplements versus partial integration allowing supplements, is a highly targeted area on the MB.
Oh, they love testing that.
But wait, I need to push back here. Because if I'm sitting in the exam room, sweating, staring at a multiple choice question, how do I actually know what the parties intended? I can't read their minds.
You don't have to.
How do I know if the contract on the page is totally integrated or partially integrated? Am I just supposed to guess based on how formal it sounds?
You never, ever have to guess. The examiners will embed a structural clue into the fact pattern, and your source text explicitly tells you what to hunt for.
What's the clue?
You are looking for a merger clause.
Ah, the merger clause.
Yep. A merger clause is a specific provision within the agreement stating that the document contains all the terms of the deal.
Right. This is usually that very last paragraph of a contract buried right above the signature lines. It reads something like, "This document constitutes the entire agreement between the parties and supersedes all prior communications, negotiations, and agreements."
It is the ultimate expression of intent to fully integrate.
Think of a merger clause like packing your luggage for a really long trip. You put everything you need inside, you zip it shut, you lock it with a padlock, and then you just throw the key away.
The suitcase is locked.
Right. By signing a contract with a merger clause, you are telling the court, my suitcase is locked. Do not look outside this suitcase. Everything that matters is inside.
So when you spot a merger clause in an MBE question, you can immediately classify the contract as totally integrated. No contradictions allowed and absolutely no consistent additional terms allowed.
Okay, now that we've established the fortress, right, the general rule, the 4 corners, the levels of integration, now we get to look at the vulnerabilities.
The fun part.
Yeah. The source material provides a comprehensive list of scenarios where outside evidence is actually allowed in, regardless of how tightly integrated the contract is.
These are the exceptions.
Exactly. These are the secret passwords that bypass the bouncer. Let's start with the exception of ambiguity. The text states that evidence may be admitted for the purpose of interpreting or clarifying an ambiguity in the agreement.
So an ambiguity arises when a word, phrase, or clause in the contract is inherently confusing, or maybe it's reasonably susceptible to more than one interpretation.
Like it could mean 2 different things.
Right. If the contract uses a term that makes no sense on its face, the court is essentially stuck. They can't enforce a contract if they genuinely don't know what the words mean. Therefore, they are forced to look outside the 4 corners for a dictionary, so to speak.
The text specifically mentions that this outside evidence can include trade usage or local custom to show that a particular phrase had a very specific meaning to the parties.
Let's build a scenario around this.
Okay, let's say we have a totally integrated commercial contract. It has a rock-solid merger clause. The suitcase is locked. The contract states that I am purchasing 12 baker's racks from you. Now, in standard, everyday English, a dozen means 12.
Of course. But let's assume both you and I have worked in the commercial baking industry for decades. And in our specific trade, a baker's dozen has a well-established historical meaning of 13.
Okay, so you deliver 12 racks, and I sue you for breach of contract, claiming you shorted me 1 rack.
And I would point to the totally integrated contract and say, hey, the document says a dozen. A dozen is 12. You can't bring in outside evidence.
But under the ambiguity exception, I'm actually allowed to bring in industry manuals, expert testimony from other bakers, maybe even prior emails between us, to prove that in our world, dozen actually means 13.
And it's critical to understand why the bouncer lets this evidence in. You are not trying to cross out the word dozen and replace it with the word 13.
Right, I'm not changing the text.
Exactly. You are not contradicting the written text. You are simply illuminating the text. You're bringing a flashlight into the dark VIP club so the judge can see what the furniture actually looks like. The evidence clarifies the intended meaning without altering the written terms.
That distinction is brilliant. Clarifying versus altering. Let's move to the next set of exceptions, which is incredibly heavily tested on the bar. Proving a defense.
Yes.
The text explicitly says evidence may be admitted to prove a defense, such as fraud in the inducement, mistake, failure of consideration, failure of a condition, or to prove the contract is void or voidable.
When you introduce evidence of a defense, you are shifting the battleground entirely. You are no longer arguing about the definition of a word or trying to add a supplemental term. You are attacking the very existence of the contract.
I want to challenge this concept for a second.
Go for it.
If the entire purpose of the parole evidence rule is to protect the sanctity and certainty of the written agreement, how does allowing a party to bring in a mountain of outside emails to prove fraud not completely destroy that certainty? Aren't we just opening the door to the exact kind of he said, she said chaos the rule is designed to prevent?
It's a fundamental tension in contract law. I totally agree.
Okay.
But the logic really does hold up. The parole evidence rule is designed to protect valid, legitimate agreements. It protects a VIP club that was actually built to code.
Okay.
But if the club was built on a foundation of lies, deception, or a fundamental misunderstanding, the law refuses to offer its protection. If you are using outside evidence to prove the building should be condemned and torn down, the bouncer steps aside.
Oh, I see.
You aren't contradicting the terms of the contract. You are proving the contract lacks legal validity in the first place.
That makes profound sense. Let's dissect the specific defenses the text lists. First is fraud in the inducement. Fraud in the inducement basically means one party actively deceived the other party to persuade them to sign the document.
Let's use another MBE-style fact pattern. We sign a totally integrated contract for me to buy your art gallery. The contract lists the price, the location, the inventory. Everything is locked in.
Got it.
However, for 3 months prior to signing, you were sending me falsified financial statements via email, drastically inflating the gallery's profits. And I only signed the contract because I believed those emails.
Okay, so when you discover the gallery is actually bankrupt, you sue me for fraud. But then I try to hide behind the parole evidence rule. I point to the merger clause and say, look, our contract says nothing about guaranteed profits. It's totally integrated. You can't introduce those prior emails.
And you would lose that argument completely. I can absolutely introduce those prior emails, not to change the terms of the gallery sale, but to prove that you fraudulently induced me into forming the contract. The emails prove a defect in formation.
The text also lists mistake. In contract law, this usually refers to a mutual mistake of a material fact. So if we sign a contract for me to buy a specific cargo ship currently sailing across the Atlantic,
but neither of us realizes the ship sank in a storm 3 days ago.
exactly, we have made a fundamental mistake about the reality of our deal. I can introduce outside evidence, like a maritime weather report or a Coast Guard log, to prove the subject matter of our contract no longer exists.
Next on the list is failure of consideration. Consideration is just the legal mechanism of exchange. It's the value being traded.
Right, the step for swapping.
Yeah. So if you sign a contract promising to paint my house in exchange for $5,000, and you paint the house but I never pay you, you can introduce outside evidence like your bank statements showing no deposit was ever made to prove I failed to hold up my end of the bargain.
Because again, you aren't altering the contract. You are proving a breach of its core requirement.
Exactly.
That flows perfectly into failure of a condition, which the source text actually breaks out into its own dedicated bullet point.
Yeah.
Condition precedent. The text states that parole evidence may be admitted to prove a condition precedent to the existence of the contract. This is classic legal terminology that just trips people up.
Precedent simply means coming before. A condition precedent is an event that absolutely must occur before the contract legally springs into existence.
Let's build a scenario for this. We draft a beautifully detailed, totally integrated contract for me to purchase your manufacturing business for $5 million. It has a thick merger clause. We sit down to sign it.
Okay.
But as I am holding the pen, I look at you and say, listen, I am signing this, but we both agree this entire deal is completely void unless I can secure a $5 million commercial loan from my bank by next Friday. If the bank says no, this piece of paper is just recycling.
And I agree to that. You sign the document.
Right. That verbal agreement regarding the bank loan is a condition precedent. The contract has been signed, but it is effectively asleep. It does not wake up and become enforceable unless the condition of the bank loan is met.
Let's say Friday arrives, the bank denies your loan application, and you call me to say the deal is off. But I decide to play hardball. I sue you for breach of contract. In court, I hold up the signed paper, point to the merger clause, and say, look at this totally integrated document. It says he buys the business. There is nothing in here about a bank loan.
Okay, so under the condition precedent exception, I am fully permitted to introduce evidence of that verbal conversation we had right before signing. The parole evidence rule does not block it.
Why?
Because I'm not trying to change the $5 million price tag. I am trying to prove that because the condition failed, the VIP club never even opened its doors. The contract never came into legal existence.
When you look closely, all of these defenses, fraud, mistake, condition, precedent, they all share a unified underlying logic. They all address the formation of the agreement.
Yeah, they prove that something was fatally flawed at the moment of creation.
The source text actually previews this concept early on, noting that the rule does not prevent a party from proving defects in formation.
Moving down the list of exceptions, we hit the concept of the separate deal. The text explicitly says, even when there is full integration, evidence may be offered if it represents a distinct and separate contract.
This is a highly pragmatic exception. Business relationships are often multifaceted. You and I might be negotiating 3 different things at the exact same time. The law recognizes that a totally integrated contract about Project A doesn't permanently silence us from talking about Project B.
So we sign our totally integrated contract for the $5 million manufacturing business. The suitcase is locked. But the day before, we also verbally agreed that I would buy your personal golf clubs for $500.
Okay, random, but it works.
Right. The golf clubs have absolutely nothing to do with the manufacturing business. It is a distinct, completely independent transaction supported by its own separate consideration, the $500.
So if I refuse to hand over the golf clubs, you can sue me and introduce evidence of our verbal agreement. I cannot use the merger clause from the manufacturing contract as a shield to block evidence about the golf clubs.
The bouncer of the manufacturing club has no jurisdiction over the golf club. They are completely separate entities.
The trick on the MBE is identifying whether the oral agreement is truly a distinct, separate deal, or if one party is just cleverly trying to disguise a modification as a separate deal.
Right. If the verbal agreement is intimately tied to the main contract and lacks its own separate consideration, it's probably not a separate deal, and the bouncer will kick it out.
Okay. We have now arrived at an incredibly crucial juncture. This next concept is arguably the most heavily tested, most frequently misunderstood element of the entire doctrine.
We are talking about the timeline.
Yes.
The time travel exception. The source text labels this subsequent agreements, and it lays out the rule with absolute clarity. The parole evidence rule does not apply to evidence of agreements between the parties subsequent to execution of the writing.
Let's break down that terminology. Execution is the moment the contract is signed and finalized. Subsequent means after. Therefore, the parole evidence rule has absolutely zero power over anything the parties agree to after the contract is signed.
This is the golden rule of timing.
Yeah.
The parole evidence rule is a time machine that is broken. It can only look backward into the past. It guards the contract against prior agreements and contemporaneous agreements. It does not care about the future. It does not care what happens tomorrow, next week, or next year.
If we tie this back to the policy of certainty, it makes perfect sense. The law wants to protect the final document from being undermined by negotiations that happen before the parties reach their final conclusion.
Yeah.
But the law is not blind to reality. Business is dynamic. Supply chains break, prices fluctuate, relationships evolve. Parties must have the freedom to mutually change their minds and modify their agreements as circumstances change.
If you and I sign a totally integrated contract on Monday, and on Tuesday we realize we made a terrible logistical error and need to change the delivery date, that Tuesday conversation is a subsequent agreement. The parole evidence rule does not block evidence of that Tuesday conversation.
The bouncer only checks IDs from the past.
Right. If a new arrangement is made after the club is opened, it is not subject to the parole evidence bouncer at all.
The source material provides a classic, straightforward example of this dynamic, and we should analyze it deeply because this exact structure appears constantly on the bar exam. The text presents a scenario with a handyman and a homeowner named Eric.
Okay, let's walk through it. The text reads, Handyman has a contract with Eric to refinish Eric's deck for $300. That is our baseline. We have a written agreement for a specific service at a specific price. Then comes the twist. The text says, while there, Eric asks him if he could also fix the gutter for $60.
The phrase "while there" is the linchpin of the entire hypothetical. It establishes the chronology. The handyman is already physically on the property performing the work. This proves definitively that the conversation about the gutter is taking place after the original written contract for the deck was signed.
The text gives us the legal outcome. If Eric does not pay Handyman for fixing the gutter, Handyman can introduce extrinsic evidence of the oral conversation about the gutter.
And the rationale is purely chronological. The gutter conversation was subsequent to the execution of the writing. The parole evidence rule is completely inapplicable.
Let's escalate this to a more complex commercial scenario. Imagine a 10-year commercial lease for a massive retail space. The lease is 50 pages long, heavily negotiated, totally integrated, and contains a severe merger clause.
Very common.
5 years into the lease, a global pandemic hits. The retail tenant calls the landlord in a panic, saying they cannot make the rent. Over a phone call, the landlord agrees to cut the rent in half for the next 6 months.
That phone call is an oral agreement, and it directly contradicts the written, totally integrated 50-page lease.
Right. But if the landlord later tries to sue for the full rent, and the tenant tries to introduce evidence of that phone call, does the parole evidence rule block it?
Absolutely not. The phone call happened 5 years after the lease was executed. It is a subsequent modification. The parole evidence rule is entirely irrelevant to that phone call.
Wow.
Now, there might be other legal hurdles like the statute of frauds or requirements for consideration to support a modification, but the parole evidence rule itself is not the barrier.
This leads to the ultimate piece of test-taking advice for the MBE. The very first physical action you should take when you encounter a parole evidence question is to draw a timeline in the margins of your scratch paper.
Yeah.
Mark the date the written contract was signed, then mark the date of the oral conversation or the disputed email.
That is so smart.
If that oral conversation happened after the signing, instantly cross out any answer choice that mentions the parole evidence rule. It is a distractor designed to trick you.
That is exceptional advice. The timeline is the master key to those questions. Moving forward, the outline shifts to a highly specific, almost philosophical problem in contract interpretation. It addresses what happens when the parties aren't arguing over outside promises, but rather they're arguing because they secretly had entirely different definitions in their heads for the exact same word inside the contract.
The text categorizes this under the heading, where parties attach different meanings. This references a specific doctrine from the Restatement, second, of contracts. The Restatement is a massive, highly influential treatise that summarizes common law principles, and the bar examiners just love testing its granular nuances.
Let's read the exact language of the rule from the text because it reads like a logic puzzle. It states, under the Restatement, second, of contracts, when the parties have attached different meanings to a term in a contract, the meaning that controls will be the meaning attached by one of them if at the time the agreement was made that party did not know of any different meaning attached by the other, and the other party knew the meaning attached by the first party.
Okay, that is a dizzying sentence. It is fundamentally a test of knowledge asymmetry, it asks. Who knew what, and when did they know it? Let's break this down systematically with an extended analogy.
Imagine contract negotiation as a game of poker. Both parties are holding cards, their own internal definitions and assumptions close to their chest. The goal of the rule is to figure out if one party was playing fairly in the dark while the other party was peeking at the cards and taking advantage of this situation.
Let's build a concrete scenario based on a famous historical contract dispute. Party A and Party B sign a contract for the massive shipment of stewing chickens. However, the poultry industry has distinct categories. A chicken can refer to a young, tender bird ideal for frying and broiling, which is quite expensive.
Right.
Or a chicken can refer to an older, tougher bird that is only good for long, slow stewing, which is much cheaper.
So Party A, the buyer, operates a high-end fried chicken restaurant. When they sign the contract, they firmly believe chicken means the expensive young fryers. Party B, the supplier, runs an industrial farm. When they sign the contract, they firmly believe chicken means the cheap old stewing birds.
They execute the agreement, both attaching radically different meanings to that single word.
The restatement rule provides the mechanism for a judge to decide whose definition wins. The court applies a two-part test to identify the innocent party. The meaning that prevails will be Party A's, meaning the young friars, if two specific conditions are met regarding their mental state at the time of signing.
Condition 1. At the exact moment the agreement was finalized, Party A must have had absolutely no idea that Party B was operating with a different definition. Party A must be genuinely, innocently clueless about the misunderstanding. They just honestly thought they were buying young friars.
So Party A's cards are on the table and they aren't looking at anyone else's hand. That is the baseline of innocence. What is Condition 2?
Condition 2 focuses on the other side of the table. At that exact same moment, Party B must have actually known the specific meaning that Party A was attaching to the word.
This is the crux of it. Party B, the supplier, realizes, oh wow, this buyer thinks they are getting premium young friars for this cheap price. I know they are confused. But instead of pausing the negotiation and clarifying the term, Party B stays completely silent, signs the contract, and plans to ship the cheap old stewing birds, secretly knowing they are exploiting a misunderstanding.
In that scenario, the restatement brings the hammer down on Party B. The law protects the innocent party who is operating in the dark, and it severely penalizes the sneaky party who recognized the confusion but weaponized their silence.
The court will enforce Party A's definition, forcing Party B to deliver the expensive young friars at the contract price.
It is essentially a legal penalty for bad faith negotiation. If you are aware of a glaring ambiguity and you know the other person is operating under a misconception, you have an affirmative obligation to clarify it before execution. If you don't, you assume the risk that the court will use their definition against you.
On the MBE, you have to read the fact patterns incredibly carefully to spot who has the superior knowledge. Look for phrases indicating one party knew or had reason to know of the other party's assumption.
We have spent this entire time analyzing the common law, the rules that govern contracts for services, real estate, and handymen fixing decks. But the MBE requires you to seamlessly shift gears between the common law and the Uniform Commercial Code. We now have to address how the parole evidence rule morphs when we are dealing with the sale of goods.
The Uniform Commercial Code, specifically Article 2, governs transactions involving physical, movable goods. Think massive shipments of lumber, fleets of vehicles, industrial machinery, or thousands of widgets.
The source text gives us a dedicated section on the UCC parole evidence rule, citing UCC Section 2202.
Let's establish the baseline first, because the core architecture remains the same. The text states that with regard to sales contracts, no evidence is admissible to show prior written or oral agreements or contemporaneous oral agreements contradicting the contract.
So the UCC bouncer is still guarding the door against contradictions. If a written contract between two merchants says a shipment of steel costs $50,000, you cannot introduce a prior email claiming the steel was supposed to cost $40,000.
Right. Direct contradictions are absolutely barred. The fundamental respect for the written word is identical to the common law.
But that is where the similarities end. The UCC was drafted by commercial experts to reflect the messy, fast-paced reality of actual business. It is fundamentally more flexible and forgiving than the rigid, formalistic common law.
The text immediately highlights this flexibility, stating, however, a contract can be explained or supplemented by evidence of trade usage or course of dealings or performance.
Under the common law, if you wanted to bring in outside evidence to explain a term, you typically had to first convince the judge that the term was legally ambiguous. It was a high hurdle.
The UCC obliterates that hurdle. The UCC operates on the assumption that commercial contracts are written in a specific shorthand. You do not need to prove ambiguity. You can always introduce these three specific types of commercial context to explain or supplement a contract for goods.
You need to have these three terms completely memorized, and you need to understand exactly how they differ chronologically. There are course of performance, course of dealings, and trade usage.
Let's build a new metaphor to distinguish these three. Think of two commercial businesses as two people in a relationship.
I like where this is going. Let's start with course of performance. Course of performance analyzes how the parties have behaved during this current ongoing relationship. It looks exclusively at the actions taken under the specific contract in dispute.
Imagine a 12-month contract where I agree to deliver 100 standard tech bundles to your office on the first of every month. For the first 4 months, I deliver a bundle containing a laptop, a mouse, and a keyboard. You accept the deliveries every time, you pay the invoices, and you never complain.
Yeah.
In month 5, you suddenly reject the shipment and sue me, claiming that a standard tech bundle was obviously supposed to include a monitor.
I would point to our course of performance. I would introduce evidence that for 4 consecutive months under this exact contract, you accepted the deliveries without monitors. Your own repeated actions under this agreement establish what the term standard tech bundle means between us.
The UCC allows this evidence in because actions speak louder than words.
So, course of performance is the current relationship. Now let's look backward. What is course of dealings?
Course of dealings examines the history between these two specific parties in previous, completely separate contracts. It looks at their past relationships to interpret their current one.
Let's say we have been doing business together for 10 years. Over the last decade, we have signed 20 different contracts for tech bundles, and every single time across 10 years, the bundle consisted only of a laptop, a mouse, and a keyboard. Now we sign a brand new 21st contract that just says tech bundles.
If you suddenly demand a monitor under this new contract, I can introduce evidence of our expensive course of dealings. I can show the judge our 10-year history to prove that between the two of us, we have established a mutual understanding of what that phrase means. Even if the current contract is totally integrated, the UCC bouncer lets our historical context into the club to explain the terms.
Course of performance is the current contract. Course of dealings is past contracts. The third key is trade usage, which zooms out entirely. It doesn't look at our specific relationship. It looks at the broader culture we operate in. It looks at the entire industry.
Trade usage introduces evidence of how the industry at large defines a term or operates. We touched on this with the baker's dozen earlier. The UCC inherently assumes that when merchants draft contracts, they are taking the customs, terminology, and standard practices of their specific industry for granted. They don't write every single detail down because they assume the industry standard applies.
So if a dispute arises over whether a shipment of lumber was graded properly, a party can introduce industry manuals, testimony from other lumber merchants, and establish commercial standards to explain what the grading terms in the contract actually mean. The UCC bouncer always allows course of performance, course of dealings, and trade usage into the room to provide context.
But what about adding entirely new, consistent terms? We know the UCC allows you to explain the contract freely, but can you supplement it? The text addresses this in its final sentence on the UCC. Unless the contract is found to be a complete and exclusive statement of terms, evidence of consistent additional terms may be admitted.
Complete and exclusive statement of terms. That phrase is simply the UCC's unique terminology for total integration. It means the exact same thing. If a judge looks at a UCC contract and determines it was intended to be the absolute, exhaustive, completely locked suitcase of the deal, you cannot add consistent additional terms.
However, the UCC starts with a presumption against total integration. Unless the contract explicitly states it is complete and exclusive, usually via a very strong merger clause, the UCC assumes it is only partially integrated. And if it is only partially integrated, you are free to introduce outside evidence of consistent additional terms that supplement the agreement without contradicting it.
We have mapped out an incredible amount of legal architecture today. We started with the foundational policy of certainty. We met the bouncer at the door of the four corners. We evaluated the spectrum of integration from rough draft to locked suitcases. We smuggled evidence past the bouncer using exceptions like fraud, mutual mistake, and conditions precedent.
We traveled through time to see how subsequent agreements bypass the rule entirely.
We navigated the restatement's psychological test of attached meanings, and we adapted to the flexible commercial reality of the UCC.
The source material provides a brilliant, highly concentrated summary right at the very end. It is labeled Exam Note in capital letters. It reads, "Remember, evidence that would be naturally omitted from a contract and does not contradict the terms of the contract usually is admissible. Any evidence that contradicts the contract will not be admissible."
That is the ultimate algorithm for the MBE. When you are staring down a complex parole evidence question, you can cut through the noise by asking yourself two sequential questions. First, does this piece of outside evidence contradict the written text? If the answer is yes, the analysis stops. The bouncer kicks it out. It is inadmissible.
If the answer is no, if it does not contradict, you move to the second question. Is this the type of supplementary detail that parties might naturally omit from a formal written document? Is it a consistent minor addition to a partially integrated agreement? If it doesn't contradict and it adds something natural, it is highly likely to be admissible.
As you continue advancing through your study materials, the text gives us a brief preview of what is coming next. It points toward a chapter on conditions. Because we spent time today dissecting the condition precedent exception, you are already ahead of the curve. You already understand that a condition is an event that dictates whether a contract legally awakens, and you know how outside evidence intersects with that concept.
Before we conclude, I want to leave you with a final, slightly provocative thought about how this doctrine functions in the real world. We have spent this hour talking about the physical four corners of a document, imagining a piece of paper signed with a pen. But consider the reality of modern commerce.
Right. Very few deals are finalized on a single piece of parchment anymore.
Exactly. When a multi-million-dollar contract isn't a single document, but rather a chaotic, sprawling thread of emails, WhatsApp messages, annotated PDFs, and voice notes exchanged over a period of 3 weeks across multiple time zones, where exactly are the four corners?
That's wild to think about.
How does a judge define what is inside the final agreement and what is extrinsic parole evidence when the entire negotiation, modification, and execution happened in the exact same digital chat window?
The boundaries of the VIP club are dissolving. The line between the formal contract and the outside conversation is becoming incredibly blurry.
It is a massive challenge for modern courts. They are constantly struggling to apply a centuries-old rule designed for quill pens and wax seals to a digital reality that moves at the speed of light. The core philosophy of certainty remains, but the mechanics of finding that certainty are harder than ever.
It is a reminder that the law is not a static set of rules carved in stone. It is a living, breathing system constantly trying to adapt to human behavior. To our listener grinding through these dense concepts, you are doing phenomenal work. You now have the analytical frameworks, the specific vocabulary, and the mental models to completely deconstruct any parole evidence question the examiners throw at you.
You know how the bouncer operates, and you know the secret passwords.
Keep pushing forward. Trust the hours you are putting in, and best of luck on your exam. We will see you on the next deep dive.